your kids are evil and they're stealing from you. Imagine being told that when you're at your lowest ebb. Michael Gwilliam was 79 when he died in February 2022. He left behind 4 daughters, Helen, Georgina, Emily and Caroline, and a will that barely recognised them. The trouble began in early 2014. Michael became convinced his neighbours were conspiring to force him from his home. He brandished an air rifle and was detained under the Mental Health Act. The doctors diagnosed persistent delusional disorder. After discharge, Michael's beliefs shifted. Now, he believed his daughters had orchestrated his sectioning to steal his property. His sister, Sheila, and his companion, Joan, reinforced these ideas, telling him his daughters were evil. That November, Michael made his first ever will. His daughters would share just 25% and only if they didn't challenge it. Joan and Sheila took the lion's share. When Michael died, his daughters fought back. They argued their father lacked testamentary capacity, and his mind had been poisoned by illness and by family. The law. This case turned on 2 legal doctrines: testamentary capacity and fraudulent calumny. On capacity, the Banks v Goodfellow test requires a testator to understand what their will is, know their assets, and appreciate who might have claims on their estate, and have no disorder of the mind that might poison their affections. Michael understood the mechanics, but the court held that's not enough. If a testator's reasons for their gifts are driven by delusions, capacity fails. Michael excluded his daughters because he falsely believed they conspired against him. That belief was symptomatic of his psychiatric disorder and not grounded in reality. Fraudulent calumny. The court found Joan and Sheila had actively reinforced Michael's delusions. They told him his daughters were evil and wanted his money. Joan made false allegations to Helen's university. The judge found these were lies they knew to be untrue and designed to poison Michael against his children. Both grounds succeeded. The will fell and intestacy applied. The lesson. In January 2026, the High Court set aside this will because the evidence of Mr. Gwilliam's capacity was inadequate. A paralegal took instructions and ticked a capacity checklist, noting that a visiting mental health nurse believed Michael had capacity, but that nurse was never formally asked to assess him. The judge found this wholly insufficient. The checklist recorded what Michael wanted, but nobody probed why, and his reasons were delusional. The will was declared invalid. Michael died intestate, and his daughters inherited. The lesson is clear. Where there's any history of mental illness or unusual hostility towards natural beneficiaries, a tick box checklist won't protect the will. Get the best evidence you can of the client's capacity, full written or ideally video evidence. If there's any doubts, get a full testamentary capacity assessment, and if possible, follow the golden rule.